Okay, fabulous. Okay, just to get everyone in the loop, I had to chat with the guys here for the online team. So we decided to move a little bit away from just talking accounting, tax, which is a little bit trying. Moving into labor, staff issues, questions around staffing. So Alan is here to assist with that. He'll be running through his slides. Oh, sorry, I'm trying to move the mic and it's not moving. So Alan and his team are from Labor Services. So again, if you want to follow the chat later, it'll be on our website. We are and recording it. And then Alan's available to help you guys. Same thing that we do. You got questions, drop them a mail. All the information will be on the slides as well. Okay, perfect. Alan, thanks.
Cool. Good afternoon, everyone. Thanks very much for coming through today. And to the guys that are online, thanks for participating. Really do appreciate it and welcome the opportunity to speak to you. So quite an informal guy. As you can see, I've got fairlies on. So if you need to ask a question, just go ahead and ask, all right? There's no formality to it. And generally, we'll respond to the questions straight away. Unless it's something that I'm specifically going to deal with a little bit later, then I'll tell you. We're going to get to that, so don't worry about it. And I am going to be discussing some specific areas, and it's just really just for a general overview and a discussion on these. But if you have other queries that you want to ask, please go ahead and ask. You know, so I'm not talking about the CCMA. I'm not talking about what to do if you need to discipline someone or if a trade union comes to your workplace. But if you have a question like that and you want to ask, please do, because the other people might also be able to benefit from that discussion. So please go ahead. All right. Just a little bit of background. So my name is Alan Bolt, and I started consulting to employers in 1996. So I started my little business all the way back then. And it was a very opportune time for me because we had a lot of changes that were happening. In South Africa, we had new legislation coming into effect. We had new mechanisms that were being developed, like the CCMA. And there was a lot of confusion around all of these things. So I had studied, I had got a degree in psychology, and I had done some legal subjects thereafter. So I had quite a good background, and I'd been working for 6 years in the HR fields, quite a nice general background. I did a lot of training in arbitration techniques and negotiations and that sort of thing. So it was a good opportunity for me to start my own business, helping other employers out there. And it's just developed over time. So we have a concentration of clients in KwaZulu-Natal, but we also have clients in Joburg. We have clients in Cape Town as well. And we consult to employers across all spectrums. So all different industries. We have no specific expertise, although we do have a lot of people in the hospitality industry that we look after. So we've got quite a good knowledge of general bargaining council legislation, obviously CCMA rules and that sort of thing. And we've got a nice team that works here in KwaZulu-Natal. So at this point in time, we have 8 people that work for us. We have an online platform that assists employers in achieving compliance. And we've got some specialists that help us with health and safety, employment equity, skills development, all those sort of parameters. So again, if you've got questions, please ask. Chances are I'll be able to answer them. If I can't, we'll take your details down. We'll do the necessary research, and then we'll come back to you. Okay, good. All right. So this is what I want to just touch briefly on. So employment equity and the recent amendments that have come out. And then we'll touch base on the status of foreign workers in South Africa. And then there's some of you might have experienced a significant uptake in the number of inspections that are being done by the Department of Labour. So we'll just talk about what those inspections are and what to do about compliance. And then just a specific issue of misconduct that is becoming quite a problem in South Africa is the issue of alcohol at work. What do we do about it? How do we treat it, etc., etc.? So those are the 4 topics that we're going to go through. Probably half an hour worth of discussion, depending on how many questions are asked. All right. So if we talk about employment equity, I don't know, do you guys know what employment equity is? Do you know anything about the Employment Equity Act in South Africa? Anyone? So if you employ, so let's put it this way, every business in South Africa needs to comply with employment equity, regardless of your size. And within the Act, we talk about equal pay for equal work. We talk about discrimination against employees. And then we have specific issues that deal with employment and the representation of the different racial groups in South Africa, and then also male and female, as well as disabled individuals. So employment equity has been around for a long time. I think it came into effect in the early 2001, somewhere around there. And then over the years, there's been some amendments as we continue to develop. And recently, we had a couple of significant amendments that came into effect. So I'm talking about a year ago, and they were promulgated in March this year. Now, employment equity has a specific impact on certain employers. And those employers are what we call designated employers. And those employers are those people that employ 50 staff members or more, or in the past, if they achieved a certain turnover in a year. So there was a threshold, like if you owned a restaurant, for example, if you did more than 15 million rand a year in turnover, you became a designated employer. And a designated employer had very specific administrative requirements placed on them. So there were a whole lot of things that you had to do to be compliant as a designated employer. And that would include setting up an employment equity committee, having meetings every quarter with your committee, submitting creating an employment equity plan, and then submitting a report each year. So your plan would be, if you look at your business over the next 5 years, how do you want to address any imbalances that you might have in the workplace? And there's a big misconception with employment equity in the sense that some people think that it's there to drive black employment. It's actually not. It's there to drive representative employment. So we have some businesses, for example, that have a management structure that's all white. And then they've got a worker base that's all black. And they will be issued with compliance orders from Department of Labor. And the compliance orders be, you need to fix your management structure because you're not equally representative at that level. But you also need to fix your bottom levels because you're not representative either. So as an example, we had Department of Labor walk into a restaurant in a man's entirety, and they got a compliance order that said that you need to ensure that you employ 1 Indian and at least 1 white female in your kitchen. Because at the moment you're not compliant, because your back of house staff in your kitchen doesn't represent the demographics of the country. So it's very much targeted at creating an equitable distribution of employment. The flip side of that is we've had seminars in the past where we've got employers, black employers who ask, do I need to comply with employment equity? Because I'm black, I don't need to comply. And the reality is, yes, you do. The law doesn't look at any color. What applies to one person applies to the next. So even as a black employer, you need to make sure that your staff structure is representative of the demographics of South Africa. So the 2 main amendments that came into effect relating to that was, one, they did away with the turnover threshold relating to designated employers. They said, okay, if you achieve a certain target of turnover, you have to be designated. Now that's no longer applicable. But now, if you employ 50 or more people, you become a designated employer. So that is the key criteria in employment equity. As soon as you reach that number of staff members, you become then a designated employer, and there's very strict requirements that you need to comply with. The non-compliance of those criteria is significant for a business. You're talking about 1.5 to 2 million rand fine. So it becomes quite scary if you don't comply with the employment equity. So the first big change was removing the turnover threshold. They said, now we'll only stick to the numbers. So if you employ 50 people or more, you then become a designated employee. And then the second amendment was that they said that the minister will then release the guidelines according to the economically active population. So you would have to then look at the population for the country, and you need to look at the demographics for the population in your region. And that is where you should be basing your employment. So if there's 7% white population, and of that 3% is male and 4% is female, then your company should try and reflect the demographics of the area that you live in, because that's what makes the most amount of sense. So they said that the minister would then release these statistics and to the general public, so that when you build your employment equity plans, you start building them in the direction of achieving those numbers. Now, what's happened is that there's a trade union in South Africa called Solidarity. It's a very big trade union, very much involved in the mining sector and the likes. And what happened was the Solidarity launched a case with the International Labour Organization. And the case dealt with the use of race being a determining factor in employment. And an agreement was reached between the Department of Labour and Solidarity. And that agreement basically stipulated that race cannot be the sole criteria in determining employment. So it can't just be your race group. It should be other factors, including your qualifications, your experience, etc., etc., etc. So there was this agreement that was signed. The government was very happy to sign the agreement. Sorry, there's someone waiting to be entered into the lobby. Will they? It'll happen.
Sort that all out.
Okay. So happy to enter into the agreement because there's no provision in our law that says that you base employment solely on race. All the other provisions exist. Okay. The challenge to this is whether or not the ministerial declaration in terms of the economically active population, whether it's perceived as a quota. And again, there's nothing in our law that says that these are quotas. They're simply guidelines in terms of your level of representation. The problem that's perceived is that whether or not there's an enforcement on those guidelines. Because if there's an enforcement on the guidelines, then effectively the government saying you must comply with the guidelines or you get penalized. And if that's the case, then the reading is that in fact what it is a quota. So that whole position is a little bit cloudy at the moment, and it will be subject to a legal challenge. And then once it goes through the constitutional court process, we'll then get defined as to what how the amendments read. So for now, we use them as guidelines in creating our plans, and then our plans only apply to us if we're employing 50 people or more. So that's the key criteria. If any of you guys are in a situation where you do have 50 staff, this is really, really important to you. You do need to take notice of it. And it doesn't matter what sector you're in. 50 people or more you're in. What's happening is that Department of Labour will come around and they'll perform inspections. And one of the questions they ask you is, can I get a list of your staff? And they ask you for your UIF number. Once they get the UIF number, they are able to then go into the UIF database, and that UIF database will tell them how many staff you employ. So they can see straight away that you employ, say, 65 people. You provide them with a list of staff that only reflects 45, but your UIF is showing 65. Now you've got a problem. So when they ask you for stuff, be honest. Don't think that you'll be able to get away with it by not providing them with accurate information. If they see that you then are above 50, they will then ask you, can I please see your employment equity file? And the file that you present them with must contain all your policies and your procedures, your appointment letters in terms of employment equity, the training that you've done for your committee, the agendas for the committee meetings, the minutes for the meetings, the disputes that were raised at your committee meetings, how they were resolved, plus your employment equity plan, and then your submissions. If you can't show them that, then you'll be issued with what's called a non-compliance order. So if you issue with the order, they generally give you 2 weeks in which to fix it. And there's some things that you can fix, but there's some things that you can't fix. Because what they don't allow is for you to go backdate. So if they ask you for your employment equity file for the last 2 years and you've done nothing the year before, now you've got a problem because you can't go back and backdate the documentation. So they normally give you a time frame in which to remedy what you can. And then if it's still not up to date, then they'll issue a confirmatory order. And that confirmatory order is the backbone of what could be an application to the Labour Court or the institutional fine. And the fine is significant. As I said earlier, either depending on the category of offences, 1.5 million up to 10% of your turnover. So the numbers are significant. So really important. If you're employing more than 50 people or more, and you're not doing employment equity, you need to speak to someone to help you so that you can get it sorted, because the consequences could be significant. Okay, yeah. Yes. Any industry, any sector, all they do is they look at the number of people that you're employing on a UIF number. So if you've got one entity that employs all those people on the 3 different construction sites, then everyone will be linked to the same UIF number, and that'll put you above the 50 threshold. Then you have to comply. If the 3 sites were run under separate registered companies with separate UIF numbers, and each was then employing, say, 20 people, then individually you wouldn't have to comply because you're less than 50. Yes. Yeah. So technically, if the individual companies, yeah.
Can you just and repeat?
Okay.
Okay.
Okay. So the question being asked, if we have a holding company, and within the holding company are a number of different entities, and each of those entities will employ people, but if the combined number is above 50, must they comply with employment equity? So individually, if they are separate entities, then there's no need for the entities to comply with EE. Well, they comply with EE, but not with they're not a designated employer because they're employing less than 50 people. What does happen though is where you've got those different entities and those entities are designated employers, then you also have to have an employment equity plan for the holding company that encompasses all the ones beneath it. Then it gets complicated. But yes, so to answer your question, it can be no. If each entity is less than 50, then it's no. But if they are more than 50, then yes, they must all comply, and the holding company needs to comply.
So can I have a?
Yes, sure.
So if in that case, and just that it's complicated. So since it's complicated, is it possible? Does it mean?
No, it's certainly possible. We do it for a number of companies.
Or it's just that it's more expensive there.
Yes, and it requires consultation now at a different level. But yes, it's definitely be done. We do it all the time. Yeah. It's the amount of work that you need to spend to get it right. So the challenge is to make sure the framework is done. So if the grassroots is done correctly, so all the individual companies at the bottom are good to go, then the top becomes a lot easier. Okay. Yeah.
So if maybe it might be a good idea, if I'm applying for a tender, then I'm going to need more than 50 staff. I should probably chat to someone like you to preempt what I might need without doing anything, obviously, unless I get the tender.
Yeah, so
it'd be a good idea to preempt.
So there are some provisions. The first one says that once a person reaches the target, so once you get to 50 staff, you've got then 6 months to become compliant. So if you are less than 50 at the moment and you're applying for a tender, and if you do get the tender, it means that you're going to push the numbers to above 50. You don't need to do anything now. And once you do get to 50, you've got 6 months in which to get everything right. So it does give you a little bit of space, in order to get the stuff together. So you don't need to worry too much about that at the time. Otherwise, you potentially can go to a large expense without actually securing the work. So you get the work first, and then we fix it. Any other questions on that guy? It's a very complex subject, very technical, and it's something that we could literally spend a whole day talking on. So we're just scratching the surface. All right. So there's been a lot of talk about foreign workers in South Africa, whether they must stay, whether they must go. My job here is not to get involved in the politics of it. It really isn't. All we do is we look at the way in which our law reads, and then we apply the provisions that are given to us in terms of legislation. And the overriding position in South Africa is that if you are a foreigner and you want to work, you need to have the right paperwork in order to do that. So you can't sneak across the border and then come to South Africa and then pick up a job. So in order for you to work, you need to be a student. So if you're studying in South Africa, that student visa will allow you the opportunity to work while you are studying. If you are an asylum seeker, or you're here on a refugee's permit, you are allowed to work as long as that document remains valid. So you guys will know that that asylum seeker's permit is only valid for a year. After the year, it expires. When that expires, that person is no longer allowed to work. If you are on a temporary residence permit as a foreigner, in other words, you've been here for more than 5 years and you've applied and you've been granted temporary residence, then you're allowed to work. If you're on a general work visa, then you're allowed to work. And if you're on call it a corporate visa, so a corporate visa is a visa given to someone to work for a specific company doing a specific job. So you might want to attract someone from Uganda to perform a function for your business. You can do that, and then they can only work for you. As soon as their work stops for you, whether you fire them or they resign or whatever, they have to give up the right to work, and they leave. So what happened is that we had general work visas issued in particular to Zimbabweans. And over time, the Department of Home Affairs is not a very efficient place, as you all know, going to get your ID or your passport or whatever the case is. And they were unable to maintain the applications for registration. And then what happens, those documents start to lapse. So the government then granted an extension to the ZEPs. And that's now been extended for a couple of times. In December last year, it was then meant to expire. For the last time, that's what they said. It's expiring. So everybody then had to have all their paperwork ready by end of December. Before the end of December came, they then granted another extension to the end of June, which is now just passed. In the interim, the Department of Home Affairs was then, or the minister was taken to court, and this issue of the continuous extension of these permits was challenged. What they then did, before the outcome of the court case, they then extended it again to the end of December. Okay, so anyone at the moment who's on a ZEP, so the exemption permit, is allowed to work because it's now extended to the end of December. Then the judgment came out from the court case, and the judge ruled that the minister's decision to terminate those permits was invalid and unconstitutional. And the judge gave Department of Home Affairs 12 months to get their act together and to come up with a better set of regulations as to what to do. So in essence, what they did was take us to next year, June. So what we know now is that if someone's on an exemption permit, they have work until June next year. in the interim, what will come out will be a new set of regulations as to how to deal with people who are employed on the ZEPs. So for now, they can continue. But what we must note is that that doesn't apply to asylum seeker permits. And it doesn't apply to those corporate visa permits. It only applies to the general work permit. So if you've got someone who's working for you and they're on the asylum seeker permit, when that permit expires, it's done. They cannot continue working for you. They need to be on a general work visa to get the benefit of that extension to June next year. So Department of Home Affairs are issuing the asylum seeker permits. So if someone is on a permit and it's expiring in a month's time, they must go to Home Affairs and apply for a renewal. When they get the renewal, it'll give them another year, and then they're good to go. They can continue working for another year. But if it's expired, you face risk. Now, about 3-4 years ago, I can't remember the exact time, we have a lot of clients in the restaurant industry, and Department of Labour know that. I got a phone call the morning from one of my contacts at home at Department of Labour, and they said, "Hey, Alan, just let your Spur Corporation clients know that we're coming for them. We've received a declaration that every Spur in the country will be visited by Department of Labour and Department of Home Affairs within the next 7 days. And they'll be wanting to see work permits for foreigners." And it was a mad rush. But what happened was, in Joburg, there was a store where they came in and these guys had all their paperwork ready and they supplied it to Department of Home Affairs. And unfortunately, 3 of the permits were issued were fake. And they look legit. I'm going to tell you now, I've seen those permits and they are proper. You would never say that they are fake. It's a Department of Home Affairs stamp and everything. Only way we know that they're not fake is when we run a verification against the number. It then pulls up that the document doesn't exist. But on the face of it, they look proper. And because there were 3, they then called them undocumented foreigners that were working, the store was issued with a 300,000 rand fine. In Cape Town, they had staff working there with no papers, not even fake ones, nothing. The senior manager on duty, hey, not the owner or the shareholders or the directors, the senior manager on the floor was arrested. You are the most senior person here today, you come with us. And that poor oak spent the weekend in a cell pending his bail application because there were 2 undocumented foreigners on the floor. So that's a problem. So there's a very real risk attached to employing people without the paperwork. And even when you employ someone, if their paperwork is legit, you have a responsibility to make sure that it's always legit. So you get a work permit, you get to a verification agency, you contact us, we'll verify the permit against the system to see if it's valid. Or you can email that same permit to Department of Home Affairs. There's an email address, verifications, and they will then check to see whether it's legit or not, and then come back to you. Yes.
The maybe Labour Relations Act create an obligation on the employer to conduct such verification, because these things, they don't come cheap. You mentioned an agency, and that agency obviously would require some form of compensation. There's so many onerous things that the employer is burdened with, and if you were to calculate all those costs, they're quite exorbitant.
So it's a very interesting question. So the question is there an obligation on employers to conduct a verification on foreign employees? So unfortunately, our law does put the obligation on you. They say you want to employ them, so you need to then verify. If you don't want to incur the cost of going through a verification agency, then they do open the door to say you can send that permit by email to Home Affairs, and they will then come back to you and say it's legit or not. Don't expect a response anytime soon, but you can do that, And we've had cases where the employer's shown Department of Labour, this is the permit that, and there's my email asking, can you verify, please? And they've accepted that. Even though we haven't got a response back, they've accepted it. Alternatively, you can use an agency to do the verification. And it's actually not that expensive. What do we charge? 30 Rand. So 30 Rand to do a verification ID, I mean, a permit, and ID verification is 20 Rand. And the criminal check is 350. Yeah. So it's actually not that expensive. There are people out there that will take you for a ride, but it's actually not that expensive. But as I said, if you want to, you can email it to Home Affairs and ask them to do the verification. Ultimately, it's their job anyway. The Department of Labour is happy with that. It's okay, well, you've done the work. We'll accept that until sometimes you get a rejection. If you get a rejection, that guy can't work. Simply can't.
Quite interesting, because if no fairness, I accept that it can be placed on the employer. The person is here within the jurisdiction of the government. And as such, I believe that also the government, just as a side mention, should be taking some form of accountability, to the effect of the person is here.
Yeah, you won't get an argument from me on that. You won't get it. Should we leave it there? But so what there is, that there's more obligation placed on you if you do discover that the document is not real, or if you do discover that one of your staff working is not documented, or their passport, their documents have expired, then you do need to deal with them. And the Labour Relations Act tells you how to deal with them. So you can't just go to an illegal foreigner and say to them, hey, you can't work here, you must go, cheers, goodbye. Because the CCMA has jurisdiction to deal with unfair dismissals placed by undocumented foreigners. So even if they don't have their paperwork, they can still take you to the CCMA, say, listen, you dismissed me unfairly. So you still have to follow due process. So there's a layout. I mean, the guidelines that we give to employers who phone us, say, listen, I've got this guy working, and I've realized that his papers are expired. What do I do? So to first issue an ultimatum. Say to me, you've got 7 days. Either from your leave, which we'll deduct, or 7 days unpaid. But I need you to come back to me in a week's time with your paperwork. If they don't come back to you with the paperwork, you then issue them with a notice to attend a hearing for incapacity, because they're not capable of working anymore. And then you dismiss them after the hearing for incapacity. And now you've ticked all the boxes. You've done the verification, you've confirmed that the document's expired, and you follow due process in terms of the labour relation. Now your hands are clean now. Now you've done everything. So, but that is the process. You can't simply just go to them and say, listen, you need to go. You actually have to follow due process. Okay, any questions? Yes.
Employees, my company, I then go and deploy undocumented foreigners to me as unemployed. This setting. How does the law view it? Will they penalize me, or will they penalize
The client? So the question asks is, if in the instance of a business performing a service to a client, and the business employs undocumented foreigners, does the obligation fall on the employer or on the client? So it falls on the employer directly. So where there's dual responsibilities, where I think you might be coming from, is the issue of outsourced staff. So where you have, and if we take this setting, for example, let's say you employ 10 waiters and 10 back of our staff on an outsourced basis to Kings Park. So you then are a service provider to your client. If you mistreat your staff So you don't pay them in accordance with the national minimum wage. They have a claim against you. They also have a claim against your client, because effectively they're working in here for your client. So there's a dual responsibility. So that you need to be aware of. If they are working for you and they work for you here for a period longer than 3 months, then there's what they call deemed employment. So the relationship then starts to link very closely with your client. So I think that's where the question comes from, is more around outsourcing of staff and not anything to do with foreigners. And that's also a minefield in terms of how to regulate. But there's nothing wrong with the process. So we have a lot of people that perform outsource services to clients. And the overriding criteria is you make sure that your contracts are in place, make sure the contracts are very specific to the function that they must perform, and you make sure that you are compliant in terms of legislation, so that you are paying the correct wage, you are paying Sunday pay and public holiday pay, etc., etc., etc. Then there's no need for a claim. If you dismiss one of them, then the claim is against you. It's not against the client. Okay. All right. Good to go. Yes. So let's distinguish. So the question we ask is does it apply to a principal and an agent? So we can have agency agreements with individuals where I don't employ that person, but I retain them on an agency agreement. So they are an independent contractor. So they're not part of an employment relationship. So I'm an independent contractor. To all our clients, I'm an independent contractor. However, there are very specific criteria to be met when determining, is someone actually an independent contractor or are they an employee? And one of the first questions that are asked is time. Do you control their time? So if you're saying to someone that you are an independent contractor, but I need you here at 7 o'clock every morning and your working hours are 7 to 5. Actually, they're not really an independent contractor, because now you're controlling their time. So a true independent contractor is controlled by output. So quality of work. So I might have a plumber, and it's a great example, because when I say to the plumber, I need you to come and I need you to do that, there's the job. They will do that job, and when that job is finished, they leave. I'm paying them on the basis of completion of that job. So that you can do. If you've got like in a sales position, so there are a lot of people around that are agents for different products. So they will go to a spa, for example, and they will then sell a basket of products to the spa. But that basket of products is not owned by one person. So they actually contracted to like 5 or 6 different companies to sell their products, and they get paid a commission. So those, perfect. It's a great opportunity for an agency agreement or an independent contractor. So that works well. But as soon as you start to dictate time, if you dictate money in the sense that they earn 75% of their earnings from one person, the relationship becomes more of an employer-employee as opposed to a contract. So yeah, so there's a whole string of criteria, and the contract that's provided between you and that person is very specific. Where you agree on a whole number of principles to make sure that there's no expectation that, okay, I'm an employee. Does that answer your question? Thank you. Yes. 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 Yeah, so where you work, the hours that you work, who you report to, your distribution of income, all those become factors in determining, is this an employee, yes or no? And there's lots of different contracts that you can use to provide for a job to be fulfilled. So if you have like extensive IT work that needs to be done, and if you go to an IT company, it's going to cost you 2 million rand, but you can employ someone and pay them their salary, and it's going to cost you 700,000 Rand, but you also know that's only going to be applicable for 9 months, then we create a contract for that. So you're an employee, but you're only employed for 9 months. And in the 9 months, this is what your requirements are. And then you treat them like an employee. But at the end of the 9 months, the contract ends and off they go. So there's other ways to get around that. Yes, sir. Yeah.
Did you specify that something?
So the question asked is essentially is what should go into a contract of employment, and can a client dictate those criteria? I would certainly not suggest that you allow a client of yours to dictate what should be in your contract, other than that which is legislative, so that which you need to put in. So your contract should really include things like, apart from the obvious, name, ID, and all that sort of stuff, it should include the nature of the role and what's required in terms of the role. So a job description or a work standard, or, just even if it's a basic paragraph explaining what the basic functions of the role, that should definitely be included. And then your other legislative provisions in terms of leave, sick leave, family responsibility leave, all those things need to be included. Your confidentiality clauses, that must also be included. Issues of notice, how do we terminate the contract? So there's a lot of specific detail in that which needs to come into effect. What you've got to be careful of is when you advertise for employment. So if you've got a project that you need to now employ people for, when you advertise, you be very careful about how you word that advert, because you can't put anything in that advert that might be discrimination. It's got to be the type of role that is looking to be filled, the qualifications that you are looking for, that are needed for that role, the year's experience that you have, and then the general qualities of the person that you're looking for. It can't be gender-based or race-based or anything like that. Where you find what they call fair discrimination is when there's a specific requirement attached to the role. So, for example, a Christian-based school might be looking for a teacher, and they might be looking specifically for a Christian teacher to teach religious education in school. So there you can be very specific on the type of person, because you can't have a Muslim applying, for example. So there are certain criteria that you can put in there, but it must be very specifically related to the job. And that's where clients will interfere in the process, because they'll say, no, I want this type of person to be working here. You say, I can't put that in my advert. And when you're recruiting and you go through that selection process, you need to make sure that you're selecting that person based on the fair criteria. Do they achieve all these boxes that are needed to be ticked in terms of the advert? And then once they've got that bunch, then I select the best one of the bunch. So yeah, so I think sometimes clients do get like that, and they start interfering in the way in which you need to advertise, but ultimately they're not going to be held accountable. You're going to be held accountable. So you need to make sure that you do it correctly. Okay. All right. So I'm doing a half a time, eh? Good. Okay. So there's been a lot of there's been an increase in activity from Department of Labour. We're not too sure why, but they seem to be going through the different compliance issues. So we've had a lot of employment equity audits that were taking place, and now the big move is occupational health and safety. So they're now coming into businesses and they want to see your safety file. They want to see your safety file, and they want to see what's in the safety file. Do you have your letters of appointment for the people that sit on your safety committee? Have these people been trained? Can they see the certificates? They want to see the first aiders. They want to see the health and safety reps. And then they start asking for the minutes for your safety meetings, etc., etc., etc. There's been a big uptake in health and safety. And to a large extent, employers have ignored health and safety. Just we don't put enough attention to it. And it is a compliance issue. And if you don't have it, you actually can get fined. So if you're running a business, you need to have health and safety file. So put that on your list of things to do. And then if you need assistance, you just call us and we'll give you some guidelines. But that's something that you need to start working on. UIF. So we have a significant problem with UIF at the moment. You'll probably be able to verify that too. So when you run a payroll, at the end of each month, you can update the payroll with UIF electronically. So you attach the file, email it to UIF, UIF imports it into their system, and it updates your UIF profile. So that includes then all the people that are on your payroll, their details, and then how much they've earned, what their contributions are. So then the UIF portal remains up to date. Problem is that's not working. So companies are sending their information off as if everything is great, but the reality is when it lands that side, nothing happens to it. Doesn't get updated. And now we're getting compliance orders being issued against employers to say you're not updating your UIF profile. And then we have to show them. Here's all the emails that are being sent. These are all the attachments. And then ultimately they come back and say, well, your profile is still not updated and it's your responsibility. So now what has to happen, you still do that, but you also need to actively go into your UIF profile on U-filing to make sure that the U-filing profile is up to date. And if it's not up to date, you actually have to manually get it up to date. So you need to import the information yourself into the system. And that's a major issue because even that U-filing profile is not very stable. If those of you did COVID applications during, TERS applications during COVID, you would have realized that even on the TERS portal that we had issues. So the U-filing is not entirely different. So there are significant problems with that. But the directive that we've got from the Department of Labour as well is that the UIF office is no longer going to be accepting handwritten UR19s. So the UR19 needs to be loaded on the system, and then the printed one needs to be given to the employee to go there. But when the employee goes to Department of Labour, that information must already be loaded on the system through the U-filing profile. If it's not, they simply send the employee back to you. So we need to now make sure that you've got access to your U-filing profile, you've got the username, you've got the password, and then that you're updating it every month as and when you do payroll. And the system is not that difficult to use, but it's complicated to get into. If you had access to a U-filing profile before, maybe for a company that you worked at, it would be now very difficult for you to get off that profile and into another one, because it simply doesn't allow you to remove yourself off the profile. So that's a challenge on your own. But going forward, you need to start doing more digital UIF documentation. Okay. I've spoken about employment equity. I don't need to do any more about that. So I don't know if any of you submitted. Got a question? Yeah.
I just wanted to check.
We have contacts within Department of Labour that we access to try and sort out issues on the U-filing profile. But if you have a problem with the system, then yeah, you're welcome to give us a call. We'll help you with that. It would depend on the number of employees that you've got that you need to. Yeah. Okay. I don't know if anybody here did TERS claims during COVID. So if you were a business and you did TERS claims for your staff, they're now going around and they're auditing those TERS claims. So what we're receiving is TERS audit requests from accountancy firms that are then authorized by Department of Labor to go and perform the TERS audits. Very complex audits, a lot of paperwork that needs to be provided to them to show that the claim that you made was legit in the first place, that the claim was paid out to the staff member concerned, and that the money that you claimed is the same money that you paid out. So you need to make sure that whole loop is closed. Otherwise, the issue is called a non-compliance order, and then you could face a fine. So those TERS audits is becoming a big issue. Okay, and then the last thing just to discuss briefly is this issue of alcohol at work. So there's a recognition in South Africa that alcoholism is a disease, and as such, we need to treat it like that. We've obviously got a few party goers, yeah? And what that means is that it impacts the way in which we deal with alcohol cases at work. So there's a couple of provisions that that need to be met when we deal with alcohol. And the one thing is that we need to establish that the person is under the influence of alcohol. So a breathalyzer test is obviously a good way of doing it, but on its own is not enough. So you need to make sure that there's a report that's provided. So we call it an alcohol misuse report, and that report will tell you eyes are bloodshot, breath smells of alcohol, unsteady on his feet. It'll then paint the picture of the person who's now failed the breathalyzer. And then if you do the breathalyzer, once it's done and the reading is above the limit, obviously you need to make a record of that reading, and it's going to be witnessed by one of your fellow staff, your managers. Then the person should go and they should sit down and they should just be kept on their own for 15 to 20 minutes, and then they come back and they do a second reading. Because there have been instances where breathalyzer readings have been influenced by the likes of a hot cross bun. A hot cross bun. By the menthol sweets, I forget what they're called. You know, there's like those peppermint-based lozenges. So when someone fails a breathalyzer and there's no clear indication that they're under the influence of alcohol, no, they're steady, eyes are clear, they're engaging with you, you know, there's no smell of alcohol, just go and take a seat. Just sit down there for 15 minutes. We'll test you again just now. And that 15 minutes is enough time for the effect of the hot cross bun and the lozenge to go away. So, and I'll give you a real example. So this happened to us. We were called by a client of ours. Please can you do a disciplinary hearing for a staff member who's already on a final warning for being under the influence of alcohol, and came to work and then registered again. So they have a mandatory breathalyzer for every staff member arriving on site. And he failed the breathalyzer. So he was immediately suspended, and then he came to the hearing. And so what happened was, when he arrived for his hearing, he again had to go through the turnstile to gain access to the premises, and he failed the breathalyzer. And he's like, it's impossible. How can I fail the breathalyzer? I'm coming for a hearing to deal with alcohol, but now I'm failing the breathalyzer. And they sent him away and told him to come back again. So he then came back again, now 3 days later, and blow me down, he failed the breathalyzer again. So he said to the security guard, you do it. The security guard did it. Yeah, no problem. And then he gave the security guard the mint. So, okay, now eat the mint. Now do it. And he failed it. Then the security guard went with him to the HR manager and said, this is what's happened. And she was like, talking nonsense. They said, okay, come, you do it. And they did with her. Blow me down. She failed the test. So it can happen. Legitimately, it can happen. So when someone does fail the test, just tell them to go take a seat. Sit down. Do nothing. Don't eat anything. Don't drink anything. Just sit there for 15 minutes and then we'll do the test again. And then the second test will be the more accurate one. So what's happened in terms of the precedents that we get through the labor courts is that we shouldn't be dismissing people for being under the influence of alcohol at work if it's their first offense. So if they come to work and they are intoxicated, we send them home. We do the tests and everything, and then we send them home. When they come back to work, we sit down with them and we issue them with a final warning. So you can't come to work like that, etc., etc., etc. And we provide them with the contact details for Sanko or for the AA. We say to them, if you do have a problem with alcohol consumption, please contact these people because they will be able to help you. So you have to be seen to be giving them that guidance, that advice, that counsel. That's your responsibility. Then we issue them the final warning and then they carry on working. Not a problem. However, if they are intoxicated at work and there's an aggravating factor, in other words, something that makes it more serious. So they are intoxicated at work because they have stolen your beer. Now it becomes dismissible because it's not just being under the influence of alcohol. You're also being dishonest. Or if they're a driver and they're now driving a car and they're above the legal limit to drive a car, it now becomes dismissible because it's now more serious than just being under the influence of alcohol. So if there are aggravating factors that are happening at the time, then cases can become dismissible on the first offense. In the alternative, the recommendation is issue a final warning, counsel them, give them the guidance, and then give them the contact details for those organizations that can assist them, and then let them continue work. But on the day, please make sure that you do not allow anyone to work who is suspected of being under the influence of alcohol. Because if you do, and there's an injury at work, it's going to come back to you. So you suspect someone is under the influence, immediately remove them from their workstation. Sit them down, subject them to the tests, and then tell them to go. But remember, if they are drunk, by you telling them to go might actually put them in danger. So if that's the case, then you tell them to go find a place and sit down and wait. And they can only leave at a point in time where you're satisfied that they are at least able to make their way home without getting into trouble. So there's responsibilities on you for your staff, even on actions that they take, that you need to be aware of. Yes. Yeah. So it's a very interesting question. And the question is premised on what do we do in case. And you know what? There's a big misperception about weed. So yes, marijuana has been legalized. There's very specific conditions around which it's been legalized. But because it's been legalized doesn't mean that someone can smoke it at work. You know, it's the same as alcohol. Alcohol is not illegal, but you're not allowed to drink it at work. And you can't be under the influence of it at work. And the same applies for weed. And obviously, I mean, you can do a test if you want to. You can do a urine test, but that's a little bit complicated and sometimes messy. What it's suggested is that you do the alcohol misuse sheet or the intoxicating drugs misuse sheet, which just explains to you, eyes are bloodshot, unsteering their smell, unsteering their feet. I can smell the smell of marijuana. And it paints the picture that this person is under the influence of the drug. And then that's enough for you to discipline them. And you follow the exact same process as you would someone under the influence of alcohol. Send them home and you tell them to come back. When they come back, you issue them with the final warning, give them the guidance in terms of where they should go to seek help. And the next time they come to work and they like it, you have a hearing and you process them. Because ultimately you become the one at risk. You know, they're working in a machine or they're operating a Hasta or, you know, trying to drive a car. And it happens. Just last night, I reviewed a disciplinary hearing that was done by one of our staff, and it relates to that very same issue. It was a delivery driver, and he was under the influence of marijuana. And they picked up because the smell inside the car was so strong when the manager went to the car after work. And then got in touch with the people that did the delivery to, and they confirmed, yeah, when the guy arrived at an hour, it's only like 5 k's from work. He arrived after an hour, and yeah, he was not so lacquer. So yeah, we deal with it exactly the same as we would alcohol. Yeah. Any other questions, guys? Yeah. Yes.
Safety fund. My question is, is it mandatory for all businesses, and what would be the qualifying criteria? You know, if it's not mandatory.
It's mandatory. It's as simple as that. There's very strict requirements on any employer in terms of health and safety. And I mean, more than welcome to share those guidelines with you. Just give us your contact details afterwards and you can see them. But every employer becomes responsible in terms of legislation to meet the requirements of the Health and Safety Act. So that would be ensuring that you have compliance certificates for every piece of machinery in your business. If you've got electrical equipment, that you have an electrical compliance certificate for that. If you've got ladders, that you have a ladder register. If you have stuff that's stacked on boxes, that you meet the requirements in terms of the stacking procedures. That you have your committee in place, that the staff are trained, that you've got your health and safety reps certified and validated. So the certificate only remains valid for 2 years, that they are trained and they you got their certificate on the wall, that your first aiders are available, that your firefighters have been trained and the certificates are there. Oh, it's a lot. Significant. Yeah.
Now, I can't imagine small business. You know, and when you speak of a rent, obviously you have to pay that yes, from the peanuts. You know, I'm just imagining a small business having all these stringent requirements or compliance issues imposed on them. You know, it makes it challenging for them to sustain business.
Doing business in South Africa is not easy, boy. It really isn't easy, and it can be expensive. But having said that, it doesn't need to be expensive. It really doesn't. You know, your safety reps are your staff. So it's not someone from the outside. It's just someone from amongst your staff members who then is elected to this position of being a safety rep. So it's generally someone who's responsible, is intelligent, can achieve the qualification, and it's a 2-day training course, and they need to go through a test. Someone that you know that if there's an accident at work, that you can actually send them and let them go and do an investigation to try and establish, what happened. So it doesn't need to be someone from the outside. It can be someone from the inside. What it requires, though, is a commitment in time. So, for example, in your business, you might be the health and safety manager because it's your business. So you'll be the manager. That means you're responsible to ensure that everything is now put in place. You'll then have a committee, and if it's a business that's less than 10 people, I wouldn't worry too much about it in terms of the administrative requirements, like having the committee in that. But you need to make sure that everything else is done. But if you're above 10, then you have the committee, and it doesn't need to be a big committee. It can be like 2 people plus yourself, and you're meeting once every 3 months, and it's probably for 45 minutes to an hour. So again, it's not a huge commitment in time. Where your cost would be is just to make sure that you got the framework. You got the framework in place, all that's done. I mean, we supply the framework. I think it's $6 grand, $6.5 grand. So we provide that. We have a health and safety pack, which gives you all the detail that you need. What do you need to do? It gives you the agendas for your health and safety meetings. It gives you your risk assessments, gives you your appointment letters, all that stuff. So that's the investment that you make. The rest is up to you. Yes, you can come back to say, hey, Alan, won't you manage this for us, please? So no problem, we can do that for you. There's a cost attached to it. And then you put us on retainer, and then we'll manage it for you. That can be done, but you don't have to do that. You can do it yourself. It just takes your time. It just takes your time. But a lot of people will say, well, it's going to take my time anyway, because it's my business. So I need to make sure this stuff is done. So let me do it anyway. And then they do it. And some of our clients have got like bigger businesses where they'll appoint someone. It's okay, you're going to be the safety manager. The CEO issues a letter of authority, and that person becomes the safety manager. It's now his responsibility to make sure that, or her responsibility to make sure that everything is done. So it doesn't need to cost you a lot of money. It can if you wanted to. It doesn't need to. Yes, ma'am. Hi. Yes. No. That costs you money. Yeah. Yes. Yeah. So not only is it tax deductible because it's a business expense, you can also, if your skills development workplace skills plan is up to date, you can actually make a claim for that against your SETA. You can claim the money back. Yes. So your health and safety officer is a health and safety rep. It's just different words used for the same function. So your entire safety committee is made up of staff. The only time that you might pay someone from the outside is if you wanted a consultant to come in and like to do a risk assessment. So you as a trained health and safety representative will be trained how to do a risk assessment. But we have a health and safety specialist on our books, and she goes around to clients and she actually performs audits for them. So she'll do a walkthrough audit, she'll go and she'll examine, and then she'll submit a report that will say, listen, this is what where you're falling short, and this is what you need to do. Obviously, there's a cost for that. But again, it doesn't have to be that way. You can do as long as you've done the training and you know what's involved, you can do the audit yourself. It doesn't. So the entire health and safety process, in fact, it's promoted not to be an external function. It should be an internal function because it's such a vital component to your business. And obviously, depending on what type of work you do, it becomes more serious. But it is a vital component to your business, and you should take ownership of it. So you should know what you're doing, and you should know what your health and safety reps are doing. But you don't need to compensate. If the health and safety meeting falls in a person's off day, for example, yeah, you would need to compensate them for coming to work on their off day, because now effectively you're asking them to work when they should be at home relaxing. So then you'd need to pay them, but you don't need to compensate them. There's no requirement to give you an allowance to being a safety officer. No. Yes. Sure. Yeah. Cigarettes. Yeah, that's an interesting one. So the question effectively is around smoking at work, and the very start to the answer to your question is to have a policy on smoking at work, because it's not illegal. Anybody can smoke, but there are conditions around which you smoke. So you can't smoke indoors. Needs to smoke in a designated area. So all of those things become part of your policy. So at your workplace, you'll have a designated smoking area where people go to smoke. What your policy will also say is that we do not allow for smoke breaks. When you need to smoke, you take it during your lunch break or your tea break if you have one. That's when you go and smoke. And you're not allowed to smoke in the toilet. So if I catch you going to the toilet and you're smoking there, I'm going to discipline you. So you can control the issues surrounding smoking. You can't tell someone you're not allowed to smoke full stop, but you can tell them you're not allowed to smoke at your workstation and you're not allowed to smoke during my time. This is your habit. You can smoke during your own time and you can smoke in the designated smoking area. And I mean, some employees are so anti-smoking that they'll put the designated smoking at the far end of the car park. No shit, no nothing. So if it's raining, you must go there. That's where you must go smoke. But yeah, you can't tell someone you're not allowed to smoke. But the policy is vital. And not a lot of employees have it in place, by the way. A lot of employees just allow, oh, you want to go for a smoke break? No, go for a smoke break. At the end of the day, that person's consumed nearly an hour and a half of your time sitting outside smoking. Smoking's not allowed. So it can't be a criteria that you can prejudice against unless the prejudice is legitimate. So in other words, for example, you are a gym and you're looking for a trainer to come work at the gym. You can say, listen, we can't have a trainer who smokes because that's just not lekker. You know, it doesn't send the right image. You know, so we want a trainer who's smoke-free, alcohol-free. It's, you know, maybe not a vegan or whatever, but, you know, you get the gist. So depending on the criteria, you might be able to say, listen, we don't employ smokers, but you can't just, I mean, let's say for a waiter, for example, you can't say that we don't employ smokers as a waiter. It would be unreasonable. Yeah. Okay. Did you have a question?
Oh, okay. So that's very okay. To ask that question,
Okay.
just wanted to make what kind of action should you take if the owner of the business has a drinking problem, but still as us as the employee, like the employees are being conducted on shouldn't be drinking during the working hours, but the owner, it's like, oh my God.
So the question is, and even if I generalize it a bit more, so the question is, how does an owner enforce laws when he or she doesn't obey the laws themselves? You know, it's a challenge, eh? It really is a challenge, because employees lose respect for owners or for managers. Let's even if we take the word owners out of the question, employees will lose respect for managers where they see managers don't themselves behave in accordance with the law. You know, it creates disrespect. It creates insubordination, because now if I don't respect you, I don't really need to listen to you. You know, it then generates into non-compliance with instructions, and it can become a bit of a mess. In terms of approaching your employer to say, listen, I think you've got a drinking problem, you might be playing with your pension fund. I don't know. It's a challenge. Eh? Yeah, tricky one. Any other questions, guys? Yes. Yeah. 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 Certificates. Yeah. Yeah. Competencies. Yeah.
Yes.
Yeah.
Is there anything?
So the question relates to when using a breathalyzer machine, what are the technicalities around making it a legal document? And it is a problem with breathalyzer machines. They do need to be calibrated, and the calibration certificate is valid for a period of time. So that certificate must always be updated, and you must always keep a record of it. In terms of a competency, there should be a record that the person who's administering the test has been trained in the operation of the breathalyzer. So it's not so much a competency certificate, but there should be a record of training that's been done. So what happens is these things create holes for attorneys acting on behalf of employees at the CCMA, and they start punching holes and things like that, and it becomes a problem. So in a lot of cases, we recommend to employers, please don't spend the 7,000-8,000 Rand on a breathalyzer machine. Just go to the chemist and buy a couple of bags, you know, with the crystals. Because when the crystals change color, it means you're under the influence of alcohol. There's no calibration. I don't need to be trained. You just blow. And when the changes color, you're guilty. It's as simple as that. So in businesses where they don't need to conduct like regular tests, where buying bags will just cost an absolute fortune. That's what we say. Just go get 5 or 6 bags, leave them in your office. They do have an expiry to them, so you just make sure you keep within the expiry. And then if you have an incident work, please blow in the bag, because the machines can become complicated. So what like we do a lot of work for schools, a lot of private schools. So what they do is they will have more than one machine, both calibrated with a valid certificate, with an administrator that's been trained. First test, you fail, take a seat, and you wait. On your repeat test, it's with the alternative machine. So it becomes a very difficult argument to say it was a faulty machine when I'm getting similar readings from two different machines. And that's one way around. But then they're spending maybe 20 grand on two machines. It becomes expensive. Yeah. Yes, ma'am, you had a question. Blow. So the question is, what do you do if an employee refuses the breathalyzer test? So in fact, an employee can refuse. In terms of the Constitution, they have the right to that privacy. So you can't force a breathalyzer. The only time that you can is when you have rules in place that say you are not allowed to enter these premises without blowing. So then when the person comes to work, they must blow. If they don't blow and they don't get into work, they're then marked as absent. So we don't discipline them for not blowing. We discipline them because they're absent from work. So they can refuse to blow. But if they refuse to blow, then you still fill in the document. So the alcohol misuse report, and that will then paint the picture, because it'll tell you that the person smells of alcohol, unsteady in their feet, etc. And already you believe, okay, this guy's probably drunk. The fact that they didn't do the breathalyzer then counts against them, because when we present it as evidence, we say to the presiding officer that the employee had an opportunity to show that he was not drunk by doing the breathalyzer. He chose not to. So in as much as I can't then use that to say he is drunk, but there's my evidence to say that he probably was drunk anyway, and it's good enough. So you still continue the process. Also remember on the issue, when someone is under the influence of alcohol, you cannot give them any paperwork. So I'm here, I'm at work, I'm drunk. You do the test, it confirms that I'm under the influence. The prerogative is to remove them. Please go. You cannot remain on the premises. You need to go. Report back to work tomorrow. You can't give them any paperwork. The reason why we can't give them paperwork is because they're incapacitated. We're saying you're drunk, so therefore I'm telling you that you are under the influence. I can't then give you a document because you do not have the capacity to handle the document. So it happened just years and years and years ago, where the employer found the person, did the test, and then issued them with a notice to attend the hearing on the same day, and then told them to leave. When the hearing came, they didn't come. Didn't come to the hearing. So we dismissed them. And we went to the CCMA, and we said to the commissioner that the employee didn't even bother to come to the hearing. And the employee's response was, what hearing? I didn't know I had a hearing. And the employee said, no, I gave you the form. Oh, I didn't get a form. And then the commissioner asked, when did you give him the form? Not on the day that he was drunk. Oh, can't do that. He took it, threw it away, didn't even realize what it was. So you can't give me any paperwork. You actually just have to tell them to go. Please leave. And then when you come the next day, now I can see that you're sober. Now I'm going to give you your paperwork. And the paperwork is a notice to attend the hearing, or you're going to issue them with a final warning. You can't just dismiss them. They must be given that opportunity to come to the hearing, explain why they were like that, whatever, you know the stories. They must be given an opportunity to explain. And only after the hearing, then you decide what to do with them. Okay. Okay, we're good to go. I'm going to be here for a while, so just sit here. So if you've got a question you want to ask, come and ask me, right?
Yeah, guys.
Okay.
Alan, thank you. Really appreciate it. Don't tell the guys online that there's snacks. So you can chat to Alan while you sort of enjoying those snacks. But thank you. Thanks, everyone. Appreciate it. See, a lot more people attended than we originally thought. So that's awesome. It just shows how and important these things are. So it's actually great. Thanks, Nathan. Ed, thank you. Eh? Cool.
Thanks,
Cheers.
Tyrone. Thank you, Alan.
Thanks,
Thank you,
everyone.
everybody.
Tinha easy. Yeah, stress, I don't like stress. Stress over me. Why? I don't understand. This was stress. Like millions I just, she's not so good, like that. I don't know what I'm to do.